Most Americans hear about immigration courts and instinctively treat what happens there as a political controversy. One side says the government is enforcing the law more aggressively. The other says fairness is being undermined. But that framing misses the deeper point. What we are looking at is not simply a disagreement over policy. It is what happens when adjudication is placed inside a structure that was never designed to produce independent judgment in the first place. Immigration courts sound like courts. Judges wear robes, hearings are held, decisions are issued, but structurally, they are not courts in the constitutional sense. They are administrative bodies housed inside the Department of Justice. The same executive branch that sets immigration enforcement policy also employs, evaluates, and can remove the people deciding individual cases. That single design choice determines everything that follows. The Constitution took the opposite approach for a reason. It assumed that if those who decide cases are dependent on those who want particular outcomes, the decisions will eventually reflect those pressures. So it removed the leverage. Federal judges cannot be fired for their rulings. Their pay cannot be reduced. Their decisions can be reversed, but only by other courts applying law, not by supervisors enforcing policy. That is not an ethical aspiration. It is a structural barrier against influence. Now consider how immigration courts actually operate in practice. Judges' decisions are tracked and compared, including how often they grant relief like asylum. Supervisors within the Department of Justice can review those patterns. Internal directives can signal that certain outcomes, such as granting release from detention or approving claims, are disfavored. Judges may be required to justify decisions that go against those expectations. At the same time, judges who are perceived as out of alignment can be removed, while new judges are hired with backgrounds more consistent with enforcement priorities. None of this requires an explicit order to rule this way. The structure does the work. Once adjudicators are employees of the same entity pursuing a policy goal, a self-reinforcing cycle emerges. The policy sets expectations. Those expectations shape decisions. Decisions are measured against the policy. Judges who align are retained. Judges who do not are replaced. Over time, the system produces outcomes consistent with its governing objective, not because every individual intends to abandon fairness, but because the incentives leave little room to do otherwise. You can see the effects in how outcomes begin to converge across the system. Relief that was once granted at varying rates becomes consistently rare. Detention becomes more common, not necessarily because each individual case warrants it, but because the system has shifted toward default denial. People held in detention for months or years begin to abandon their claims simply to regain their freedom, even when they might otherwise have continued. The number of completed cases increases and backlogs shrink, not because each case has been carefully adjudicated on its merits, but because the system has become more efficient at producing final removal orders. So, efficiency is often presented as a success, and from a policy standpoint it may well be, but it does come at a structural cost. The individual case, the core unit of due process, becomes secondary to system-wide output. The question shifts from what does the law require in this case to how does this case fit within the broader enforcement objective? That shift isn't the result of bad actors, it's actually the result of design. In a constitutional court, the triad is fixed. The purpose is neutral adjudication. The mechanism is independence from political control. The application is the resolution of individual cases under law, subject to external review. Each part reinforces the others. Independence protects decision-making. Decision-making produces lawful outcomes. Lawful outcomes reinforce the legitimacy of the system. But in an administrative system like immigration court, the triad inverts. The purpose becomes policy execution. The mechanism is hierarchical control. The application is outcome alignment with administrative goals. Each part reinforces the others as well, but in the opposite direction. Control shapes decisions. Decisions reinforce policy, and policy in turn justifies further control. That is why calls to protect judicial independence in this context miss the mark. Independence isn't something you can just restore through guidance, training, or, well, better leadership. It has to be built into the very structure. If the same authority that benefits from a particular outcome also controls the people making the decision, then independence is already compromised, and no amount of professional norm setting can reliably counteract that. Consider how detention decisions actually work. In a neutral system, a judge evaluates whether a person poses a flight risk or a danger to the community, and does so based on specific facts. That's an individualized legal judgment. But if the system shifts toward discouraging release, whether that's through policy directives, supervisory scrutiny, or performance expectations, the default changes. Detention becomes much more common, and detention itself creates pressure. People who might otherwise pursue valid claims begin to give up, simply to avoid prolonged confinement. The outcome is shaped not just by law, but by the conditions imposed during the process. Again, this isn't accidental. It's exactly what happens when decision-making authority is embedded within a chain of command. It's no accident this system targets the most powerless in our society. The people subjected to immigration courts cannot vote. They do not meaningfully shape the political system that governs them. They have no electoral leverage over the officials who design, control, and benefit from the structure they are forced into. That is the enabling condition. Without it, this system could not exist in its current form. No elected official would construct a system like this for people who could remove them from office. No administration would openly monitor judges' decisions, pressure them toward preferred outcomes, remove those who resist, and reshape the bench to produce consistent results if the people subjected to those decisions could respond at the ballot box. The political cost would be immediate and unsustainable. But here, there is no such cost. That is why the structure looks the way it does. It is not an accident. It is not a neutral failure of institutional design. It is a deliberate allocation of power over a population that has been excluded from the mechanisms that would otherwise constrain that power. And once that exclusion exists, everything else follows predictably. Adjudicators can be placed inside the same chain of command as the policymakers whose goals they are expected to advance. Their decisions can be tracked, evaluated, and compared. Pressure can be applied. Those who resist can be removed. Those who align can be promoted. Over time, the system produces outcomes consistent with political objectives while maintaining the outward appearance of legal process. This is not a breakdown of the system. It is the system functioning as intended. What makes it especially insidious is that it is cloaked in the language and symbolism of justice. There are judges, there are hearings, there are written decisions. But those features do not create fairness. They create the appearance of fairness. Underneath, the defining characteristic remains. The people being judged have no meaningful power over the system judging them. That is the condition that allows everything else to happen. And it is impossible to ignore who those people are. They are overwhelmingly non-citizens, often poor, often detained, often without legal representation, often navigating proceedings in a language that is not their own. They are, by design, the least politically protected group within the system. That is not incidental to how this structure operates. It is the reason it can operate this way at all. A system that concentrates power over a politically voiceless population, strips away structural independence from adjudicators, and then uses that arrangement to drive outcomes aligned with enforcement priorities, is not simply flawed. It reflects a deeper willingness to deny basic legal safeguards to those deemed outside the political community. That willingness has consequences. It means that the principles often invoked as foundational, fairness, due process, equal justice, are applied selectively. They are treated not as universal constraints on power, but as privileges that can be withheld when politically convenient. You cannot separate this from the country's broader history. Systems that operate with reduced safeguards have repeatedly been imposed on groups without political power, justified at the time as necessary, efficient, or exceptional. Only later are they recognized for what they were: exercises of authority, unconstrained by the principles that were supposed to govern it. The immigration court system, as structured, fits that pattern. It is not enough to say that it is vulnerable to abuse. It is built in a way that invites it. It is not enough to say that individuals inside the system should act with greater restraint. Those individuals operate under conditions where restraint is penalized and alignment is rewarded. It is not enough to suggest incremental reform. The core problem is not procedural. It is structural and political. A system that combines prosecutorial authority and adjudicative authority within the same hierarchy, applied to a population that has no meaningful political recourse, cannot reliably produce justice. It can produce decisions. It can produce efficiency. It can produce outcomes that satisfy policy goals. But it cannot produce the kind of independent judgment that defines a legitimate court. And that is the point that has to be faced directly. This is not an unfortunate gap between ideals and reality. It is a system designed to exercise power over people who cannot effectively resist it, while maintaining a facade that suggests legality and fairness. As long as that structure remains intact, the results will not change, no matter who is in charge. If the goal is genuine justice, then the conclusion is unavoidable. A system built this way cannot simply be improved. It has to be discarded and rebuilt so that adjudication is removed from political control and subjected to the same constraints that govern real courts. Anything less leaves the underlying dynamic untouched. Power over the powerless, exercised through a process that looks like justice, but is not constrained by it.